I am Bill Rochelle, editor-at-large for American Bankruptcy Institute. We're coming to you on Saturday at ABI's annual spring meeting. With me now is, well, I guess I could probably say maybe my favorite former judge, because you're now former, Eugene Wedoff, a bankruptcy judge in Chicago until he stepped down and retired in December. Since then, Judge Wedoff has decided to embark upon a career where he is exclusively going to do God's work. And not only that, he's going to do it pro bono. What do I mean by that? Well, Judge Wedoff has told me that he is going to accept appellate assignments in cases that raise interesting bankruptcy law issues. And I assume, Judge Wedoff, that this means that you're mostly going to be representing consumer debtors who can't afford to take matters up on appeal. Is that right, or what else might you be into?
Well, Bill, I expect when I put out my plea, and I am putting out a plea for any party, whether it's a debtor, a creditor, a not-for-profit organization that needs to appeal or defend against an appeal in a bankruptcy case, I would be happy to consider representing them at no charge. And my thought is that this allows issues that otherwise wouldn't be resolved at a higher level to be resolved, making bankruptcy practice a little more uniform, but also providing some assistance to people who deserve it and can't afford it.
Yes. And although you're from Chicago, I gather you're not going to limit yourself to issues in the Seventh Circuit, is that right?
That is exactly right. My first appeal was in the Eastern District of New York.
Well, let's talk about that.
We have to.
Well, that's a case called Zaire, and I reported it in my column within the last week. You won big time before bankruptcy judge Alan Trust in the Eastern District of New York.
Well, it would be fairer to say that my predecessor counsel, my co-counsel, won big time before Judge Trust. They did. The issue is whether a debtor who has ownership of underwater property, subject to a mortgage.
Whoa. This, in your case, is not just underwater in terms of mortgages.
No.
Tell us exactly what were the facts in terms of the problem with that property.
I think of the storm as Hurricane Sandy.
It was.
The New Yorkers call it Superstorm Sandy because it had lost its hurricane status before it hit New York. Nevertheless, it was a very powerful storm. And the Zaire's property on Long Island was pretty much wiped out by this storm. It was no longer habitable. They had to move. The property, however, was subject to a substantial mortgage, as a lot of New York property is, and because of that, they needed to go into Chapter 13 to avoid responsibility for paying that mortgage while they now had to pay for their current housing. That situation led their Chapter 13 attorney, my co-counsel, to propose a plan that would have that property revest in the mortgage holder.
Now, they got rid of their personal obligation on the mortgage through Chapter 13.
They'd be in the process of doing it.
Yes,
they wouldn't get the discharge,
until
of course, till the end of the case.
Right.
But they were in the process of doing that, and the automatic stay prevented any collection of personal liability.
So what's the problem that they were trying to get rid of with the mortgage if they no longer have a personal liability to the lender?
The problem is that the owner of the property is going to have personal responsibility for any injury that might occur on that property. So they have to maintain insurance, and they have to do their best to make sure that the property is protected from someone going in and hurting him or herself.
Right.
So there are definitely costs involved in continuing to own that property.
And so what did the plan provide?
Plan provided that in payment of the secured portion of the mortgage holder's debt, the mortgage holder would be paid by transferring the property to the mortgage holder.
Aha. So you're really going to vest title in the secured lender.
That's right.
As part of the plan.
Right.
Did the lender consent or not?
The lender did not consent, and this is kind of the amazing thing. The lender wants to have the benefit of a lien. The lender wants an interest in the property, but the lender is unwilling to take title to the property. The only explanations that I can give to that conundrum are, number one, they would like the debtor to bear the expenses of ownership while the property may be increasing in value, or number two, they can't get approval from whoever the real owner of the property is to engage in a short sale or other transaction that would allow for the transfer of title.
Mm-hmm. Now listen, on this question of whether you can force vesting of title through a Chapter 13 plan, are the courts around the country consistent, or are they split on the outcome?
There is a very dramatic split. I think with the unfortunate result that I just got from the Eastern District of New York this week, the total would now be 9 saying that this is impermissible over the creditor's objection, and 5 saying that it is permissible.
Well, now, what is the theory which says it is permissible to compel a lender to take title?
Well, there's actually 2 different provisions of 1322B that apply here. Now, 1322B is a provision that gives debtors options for Chapter 13 plans. The plans obviously are drafted by the debtor. They have to be in Chapter 13. And what 1322B says in one provision, 1322B8, is that property of the estate can be used to pay a claim. So that's a direct way of dealing with the situation we have here. The property is being used to pay the claim that it's secured. The next provision of 1322B is 1322B9, which says that property of the estate can be vested under a plan in any entity. One of those entities can be the mortgage holder.
Does the word consent appear in subsection 9?
No, nowhere. Now, I know of one opinion that says that consent is somehow a requirement, but it would seem to me that since these are provisions that are exercisable at the option of the debtor, unless there's a provision in that particular section or subsection requiring consent, consent is not required.
Well, it seems to be that if that's the rule, if consent is required, then this would have ramifications in Chapter 11. In other words, if you wanted to have a class of creditors in Chapter 11 where you transfer a piece of real property involuntarily to the class or an individual creditor, I would think these cases would mean you couldn't do that in 11. Do you think that's right or not?
Well, obviously, I take the position that it's not right.
Right,
that
yeah.
You can transfer property under both 13 and 11.
Right.
Now, I don't think there's a lot of disagreement about dirt for debt in Chapter 11.
Uh-huh.
So you can transfer real property in Chapter 11 in satisfaction of a claim, pretty much accepted. The argument in Chapter 13 is that Chapter 13 has special limitations on the way Chapter 13 treats secured debt. Now, they're not in 1322B, they're in 1325A. 1325A5 says there are only 3 ways that secured debt can be treated. A, the creditor consents. Well, that's not applicable here. B, the claim is paid through the plan, generally called cram down. And C, the property is surrendered. Now, in my case, the plan provided for surrender. And here's where the split comes in the cases. The majority now, the 9 cases that come out saying that you can't transfer property, say that surrender confers on the creditor the option of not taking the surrendered property. The other cases, including Judge Trust's decision in my case, say that surrender is neutral on the question of transfer of title. Surrender simply is the debtor giving up the debtor's interest.
Right.
If the debtor gives up the debtor's interest, that could obviously be the first move in a transfer.
Yeah.
Obviously, if you're going to transfer title, you have to give up your interest.
Because, by the way, Judge Isikoff, for instance, in Miami, just wrote an opinion disagreeing with a bunch of her colleagues about surrender in a different context. Mm-hmm. In her view of surrender, it's rather neutral, as you said, where she interprets the word in other contexts in 13 to mean, or even in 7, to mean that you don't give up your right to resist foreclosure or claims against the lender, things of that sort.
So that would be even a less extensive definition of surrender than what I'm suggesting.
Right.
But the point is, I don't see anything in surrendering property that confers any right on the creditor to not accept the transfer.
Right.
It's neutral.
Right.
So 1322B ought to apply and the transfer ought to be possible.
Yeah. Listen, let's cover one other issue on this orphan property question. A number of courts hold that with a condo, for instance, where there are common area charges, that a debtor in 13, or even in 7, I guess, for that matter, cannot get out of liability for post-filing common area charges?
Homeowners assessments.
Good. How do you analyze that issue? And is it something that you think can be dischargeable? That is to say, the future assessments.
Well, here again, there's a split in the cases as far as Chapter 13 is concerned. In Chapter 7, there's no question. We have a specific exception from discharge in 523A saying that the debtor remains liable for homeowners assessments post-petition. No question about that. That provision does not apply under 1328 in Chapter 13 discharges. So the question that splits the court, is there a non-dischargeable debt in Chapter 13 as well as in Chapter 7? And the argument for those who say, and I think they're a majority, that the debt remains non-dischargeable is that it's an ongoing obligation. Every new month is a new debt. And because it's post-petition, it's an expensive administration that has to be paid by the debtor.
I see.
The other way of looking at that is that it's not a debt generated every month. It's a debt generated from the pre-petition contract or deed that the debtor entered into, and therefore, because it has pre-petition roots, it's a dischargeable debt unless there's an exception from discharge.
Yeah, I see. Well, this is a really critical issue. I would say, Judge Wedoff, for consumer debtors with underwater homes, whether it's literally or figuratively underwater, it's a big issue. It's almost as big as dooснip, and whether or not the Supreme Court eventually will overrule dooснip.
It's the twin sister of dooснip.
Exactly. Well, listen, Judge, I have a feeling that a year from now we'll be back here again, probably at that time talking about the Second Circuit's disposition of your case, and at that time you will be being installed as the president of the American Bankruptcy Institute.
Yes.
We congratulate you, and I look forward to having you in that role, because I will then be reporting to you about a year from now, and I look forward to that.
Well, I have to say, Bill, you have done wonderful things with your columns, with your interviews, in advancing one of the aims of the ABI, which is to convey useful information to its members and to the world of people who are affected by bankruptcy. You've written brilliant articles, and you've really gotten ideas across in an effective way. I hope that whatever I do as president of the ABI can also advance its goals in making bankruptcy more intelligible and more effective.
Well, I think you'll do that for sure. Thank you very much, and we'll see you, Judge Wedoff, back here in about a year.
Bill, thank you very much.